You need to determine the existence and scope of the trustee's duty to account, and that's done by looking in the trust instrument. The trust instrument will determine the nature and scope of the duty to account and report. It can entirely waive an accounting. It can specify the frequency of the accountings. I've only seen one in 18 years that required an accounting every 6 months. Most of the time they're annually, sometimes biannually. But look at the trust. And now it's important to remember that if there is a waiver of the duty to account, that waiver does not apply when the trustee is a disqualified person. And disqualified persons are defined in Probate Code Section 21350 or 21380, depending on when the trust became irrevocable. So you do want to be aware of whether or not the trustee is a disqualified person before relying on a waiver. The trustee also has a statutory duty to account, so you want to take a look at that, and that's Probate Code Section 16062. And 16062 provides that a trustee must account at least annually on the termination of the trust or on a change of trustee. Even if the trust instrument waives an accounting, you may want to consider advising your trustee to account anyway, to start the statute of limitations running. And the period in which to object will vary. If the trust instrument provides for a shorter period other than the 3-year statute of limitations. For example, the trust instrument may say a beneficiary has 180 days to account or to object to an account. So you're limited by the 180 days provided all the requirements are met, and we'll talk about that later. So once you've looked at the trust instrument and the law and you've defined the scope of the duty to account, you need to determine next who's entitled to receive the account. And so there are specific persons that are entitled to receive an account. The trustee must account to all beneficiaries of the trust who are currently entitled to receive distributions of income or principal, or to whom income or principal is authorized to be distributed in the trustee's discretion under Probate Code Section 16062. So it's very important to review the dispositive provisions of the trust instrument to carefully determine who you are entitled or who is entitled to receive an account. So the trustee also has an additional duty to report. And that duty is found in Section 16061, and unless otherwise stated, all references to sections today will be to the Probate Code. I'm sure you're all familiar with these sections in any event, but I'd like you to have that reference should you need it. So the trustee must provide a report to any beneficiary who requests it. The request must be reasonable and is not required to be in writing. And a beneficiary cannot request a report more than once every 6 months. When you account, you're going to satisfy your duty to report as well. And so often people don't think of them as two distinct duties, but they really are distinct. So your accounting may disclose certain facts, but it doesn't disclose all the information that a beneficiary needs, because an accounting is charges and credits, right? It's transactional. So you can't always tell from the nature of the transactions that are listed, what went on behind the scenes and how, so to speak, the sausage was made that resulted in all of those charges and credits and transactions. So your duty to report is to provide information to the beneficiary that a reasonable person would want to know in order to protect their interests. So that is a separate and distinct duty. Specific persons are also entitled to receive a report. A trustee must report information on reasonable request, and in this context, a beneficiary is very broadly defined and includes a person with a present or future interest in the trust, regardless of whether the interest is vested or contingent. And the definition of beneficiary that applies in the context of entitlement to report is found in Section 24. Now, there is an exception to the statutory duties to account and report when the trust is revocable. So despite the general requirements that accounts be provided to current trust beneficiaries and reports to a beneficiary who reasonably requests it, counsel needs to look at whether the trust is revocable or irrevocable. If the trust is revocable, the person holding the power to revoke is the sole person entitled to receive the account or report. And so I find this often arises in the context of adult children and their parents. So they may be entitled to receive a distribution when mom dies, but they want a full account and report of everything that mom's doing. They want to know what she's spending. That would not be appropriate if the trust is revocable. So if we're talking about a fully revocable survivor's trust, the children can't necessarily find out how much mom's spending to care for herself or on her trips, because they want to make sure she doesn't spend too much so there's enough left for them. And forgetting completely that it is, after all, her money.